The point is, what are we going to do with all these illegal immigrants?
Unless I missed something, Senator Clinton said two different things in the course of about 2 minutes.
She's deceitful. She'll make up any story, lie about anything, as long as it serves her purpose of the moment.
The company wanted to broadcast the film in 2008, which was an election year. However, doing so would be illegal under BICRA. Why?
Section 441B prohibits corporations from making certain independent expenditures to support candidates for federal office.
Because the Hillary movie opposed Clinton's candidacy and supported her opponent, it fell within Title II's definition of an electioneering communication. Therefore, Citizens United could not broadcast it during an election year. To avoid criminal liability,
the corporation sought a judicial determination that would allow it to broadcast the film.
Citizens United lost in the lower court. The District Court for the District of Columbia concluded that prohibition on electioneering communications was constitutional under the rule in McConnell v. FEC. In Citizens United, the court reversed its ruling in McConnell. A 5-4 majority held that the ban on electioneering communications was unconstitutional. As a threshold matter, even though Citizens United was a corporation, it was nevertheless protected by the First Amendment.
The court has recognized that First Amendment protection extends to corporations.
Justice Kennedy continued.
If the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech.
He added,
political speech is indispensable to decision-making in a democracy, and this is no less true because the speech comes from a corporation rather than an individual.
During oral argument, some of the justices worried that a ban on corporate-funded movies could also justify a ban on corporate-published books. Justice Alito asked,
the government's position is that the First Amendment allows the banning of a book if it's published by a corporation.
Malcolm Stewart, the Deputy Solicitor General, candidly replied,
the electioneering communication restrictions could have been applied to additional media as well.
Justice Alito was taken aback by the answer.
That's pretty incredible. You think that if a book was published, a campaign biography that was the functional equivalent of express advocacy, that could be banned?
The answer was yes. The government changed its position 6 months later when the case was re-argued. Justice Ginsburg asked Solicitor General Elena Kagan,
if Congress could say no TV and radio ads, could it also say no newspaper ads, no campaign biographies? Last time the answer was yes, Congress could, but it didn't. Is that still the government's answer?
With audible laughter, Kagan answered,
the government's answer has changed, Justice Ginsburg.
She added,
for 60 years, a book has never been at issue.
The court was not satisfied with that answer. Justice Scalia said,
if you write it too broadly, we're not going to pare it back to the point where it's constitutional. If it's overbroad, it's invalid.
Chief Justice Roberts added,
we don't put our First Amendment rights in the hands of FEC bureaucrats.
Justice Alito was still perplexed by the government standard.
Now, in light of your retraction, I have no idea where the government would draw the line with respect to the medium that could be prohibited.
In the end, a majority of the court would not accept the government's assurances. By a 5-4 vote, the court reversed McConnell to invalidate a ban on electioneering communications funded by corporations and unions. However, as it had in Buckley, the court once again upheld disclosure requirements. These provisions require that the identity of those paying for the advertisement be disclosed. Justice Kennedy observed that
disclaimer and disclosure provisions provide information to the electorate. The resulting transparency enables the electorate to make informed decisions and give proper weight to different speakers and different messages.
He added that the disclosure requirements may be unconstitutional.
If an association offers evidence that its members will face threats or reprisals, but Citizens United has offered no evidence here of threat or reprisals.
Study guide. Can you see how Justice Kennedy's conclusion creates something of a chicken and egg problem? A corporation cannot be threatened until disclosing its expenditure. However, once its expenditures are disclosed, it will already have been threatened. Justices Stevens, Ginsburg, Breyer, and Sotomayor dissented. Justice Stevens advocated for the doctrine of stare decisis. He objected to the court's decision to reverse McConnell as well as Austin v. Michigan Chamber of Commerce. That case upheld restrictions on expenditures of corporations and unions. Justice Stevens also offered an originalist argument.
At the founding, Americans took it as a given that corporations could be comprehensively regulated in the service of the public welfare.
He added that
they held a cautious view of corporate power, and they conceptualized speech in individualist terms.
He observed that those who
ratified the First Amendment
did not think that
they were laying down a principle that could be used to insulate corporations from even modest restrictions on electioneering expenditures.
Justice Scalia responded to Justice Stevens in a concurring opinion. The dissent's historical discussion, he said, was, quote, in splendid isolation from the text of the First Amendment. The amendment is written in terms of speech, not speakers. Justice Scalia explained that the text of the First Amendment, quote, offers no foothold for excluding any category of speaker, from single individual to incorporated associations of individuals. He added, quote, the dissent offers no evidence about the original meaning of the text to support any such exclusion. Justice Scalia concluded, quote, we are therefore simply left with the question whether the speech at issue in this case is speech covered by the First Amendment. No one says otherwise. A documentary film critical of a potential presidential candidate is core political speech, and its nature as such does not change simply because it was funded by a corporation. Justice Stevens vehemently disagreed.
Simply put, corporations are not human beings. As the court has long resembled, the distinctive legal attributes of corporations create distinctive threats to the electoral process. The rule announced today that Congress must treat corporate speakers exactly like human beings in the political realm represents a radical change in the law.
You can tell that Justice Stevens had some difficulty delivering his Citizens United dissent. In an interview, he said, quote, that was the day I decided to resign. Several months later, President Obama nominated Solicitor General Elena Kagan to replace Justice Stevens.